Welcome to Migrant World TV. I'm Tom Rainey-Smith. On September 29, the Constitutional Court handed down the decision that the current work permit system, which allows migrant workers to change their place of employment only up to 3 times, poses no legal problems. Migrant workers who entered Korea under the work permit system filed a suit in 2007, arguing that the limitation on how many times migrant workers can change their place of employment violates the freedom to choose one's occupation guaranteed by the Constitution. The Constitutional Court stated that the reason for this decision was that the current system must be maintained in order to protect Korean workers' job opportunities and to reduce labor problems for small to medium businesses caused by migrant workers' frequent change of jobs. However, they also recommended a reform of the work permit system, pointing out the critique issued by the United Nations Committee on the Elimination of Racial Discrimination that migrant workers in South Korea are being discriminated against due to this restriction on migrant workers' freedom to change their place of employment. Migrant workers are not allowed to change the occupation they originally chose when they entered the country. Moreover, the restriction on changing their place of employment often results in migrant workers becoming undocumented, without their intending to become so. If a migrant worker used up his or her chance to change his or her place of employment, i.e., if he or she changed his or her job 3 times, then he or she can no longer move to another job, even if he or she was experiencing physical violence at the workplace or his or her wages were overdue. The concerned human rights organization stated that this decision by the Constitutional Court clearly does not promote human rights in South Korea. They said that they will continue to make efforts to help reform the current system.